correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit, because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made that legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's the judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Kumar have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlala's legal team, and that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the Commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you,
Chair.
Ms. Hassim.
Sorry, Chair, there's one last point
Yes,
I've
yes,
forgotten,
yes.
and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlala's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the Commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate an instance where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that it was a very strange request. One can't quite tell whether the request was for all the questions that are going to be asked to be itemized, which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under which topics are we going to proceed on once the Commission has made a ruling with regards to whether we can proceed, or the argument that we make brings the entire process to a halt. Thank you, Chair.
Thank you. May we see counsel outside, please? The application for a postponement to tomorrow is refused. Mr. Matlala's application must be argued at 12 midday today. Let's adjourn and resume at 12 midday.